May it please the court, my name is Gross, G-R-O-S-S, initial S, and I appear with my senior counsel, Cieleska, C-I-E-S-I-O-L-K-A, initial B, for the defendant Solomon True, who is the owner and licensee at True Tone Grill. I'll be presenting submission 3 and 4 on behalf of our client. Addressing submission 3 in section 9, subsection 2, paragraph A of the Civil Liability Act 2003 of Queensland. The question of probability is if care were not taken. It can be shown with the removal and separation of the patron that our client took all necessary steps of required care and duty as established by my senior counsel in both submissions 1 and 2. Probability is discussed further in the case of Bolton and Stone 1951, appeal cases 850. His Honours rationalised that the probability of a cricket ball creating harm was possible, but the probability of such an incident was rare. Just as the incident occurring at the car park of the Bar and Grill, while it is probable that a third party committing a crime may at some point target the car park, the possibility was so remote as there had been no incidents in the previous 3 years of operation. Our client was not required to have licensed security personnel in the restaurant or the car park. It cannot be shown that our client breached his duty of care as a licensee. Addressing submission 4, causation is at Division 2, Section 11 of the Civil Liability Act of Queensland. It cannot be shown that our client caused the injuries to the plaintiff, as the scope of liability at Section 11, subsection 1, paragraph B of the Civil Liability Act Queensland would not extend to our client, because the injuries suffered by the plaintiff, as per the Modbury Triangle case, is quoted as the conduct of criminal assailants is not necessarily dictated by reason or prudential considerations. His Honour, Chief Justice Gleeson, stated at 418, the unpredictability of criminal behaviour is one of the reasons why, as a general rule, and in the absence of some special relationship, the law does not impose a duty to prevent harm to another from the criminal conduct of a third party, even if the risk of such harm is foreseeable. With this authority alone and no existing special relationship, the duty is imposed via the Liquor Act. Our client cannot be held responsible for the third party attack. In addressing factual causation at Section 11, subsection 1, paragraph A of the Civil Liability Act Queensland, it is submitted that there was no breach of duty as shown in submission 2. So therefore, it was not the necessary occurrence to which harm befell the plaintiff. Your Honour, in closing, I'd like to highlight that not only did our client reach the full potential of their duty of care towards their clients, but in fact went further than what was required, and I feel that any reasonable person would come to the same conclusion. The aggressor of the two involved parties was removed from the premises through a front entrance. And yes, it may be argued that the aggressor of the two made the comment that they would get the plaintiff. However, this can be simply argued as a comment made in the heat of the moment, under the influence of alcohol and bravado. Furthermore, the aggressor made comments that indicated they were in fact going to attend another premises altogether, with a quote that they were going to leave and go and get some peace and quiet. It is at this point that the duty owed by my client is discharged as the aggressor of the two parties has left the premises. This is very well detailed in Rooty RSL Club Proprietary Limited versus Camiri 2009 with the New South Wales Court of Appeal 2. The plaintiff then, under their own intentions, after a good length of time, exited our client's premises from an entirely separate side exit from what the aggressor did. Under the Liquor Act, our client was not required to provide licensed security personnel until the hours of 2300 and to a time of 1 hour past the last patron leaving the licensed premises. And even if there were such personnel present, there is a good chance that they would not have been within the car park at the time of the attack. Neither our client nor the plaintiff had knowledge of the other party's intentions and state of mind that they would in fact return to our client's premises and inflict these injuries to the plaintiff. Therefore, there was no foreseeability of this event even occurring. Put simply, our client cannot be held responsible for the criminal acts of a third party upon the plaintiff. Not only was there no foreseeability of this horrendous attack occurring, there was no causation between our client and the damage caused to the plaintiff through a lack of duty of care. This is highlighted through the Red Hill RSL versus Comedary case and further supported by Patelli versus Tabriska Pride Limited North 2009, New South Wales Court of Appeal 17, where the findings from the Rooty Hill case were supported. So, Your Honour, this indicates that in fact our client fulfilled their duty of care, and many would be considered to have gone beyond that.